You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And David, I think today my fear is that, well, I don't know if it's a fear really, because I really don't mind making people mad, but I really think that we're probably going to make a lot of Christians and a lot of our followers and church folks mad with our assessment. And particularly what we want to talk about today is Chief Justice Roberts' ruling with the majority in this Pentecostal church's plight in California against Governor Newsom's orders for COVID-19. So anyway, let's dive in and ruffle some feathers.
Well,
first you might want to just explain what happened in the Supreme Court.
Okay. We'll explain what the status was. California Governor Newsom has at the time the case went up. Now I don't know what might have happened in the interim, but this church, and there was another church there in California, had asked the Supreme Court directly for a stay of the governor's COVID distancing order, so that they could have assemble and worship on Pentecost Sunday, which was last Sunday. And the governor's order had limited the houses of worship to 25% of their occupancy, or 100 people. So they sued and said that's unconstitutional. And they lost. And
their argument was it was against their First Amendment right.
That's right.
Freedom of religion,
right.
Freedom to assemble, yeah.
Right. Against the First Amendment.
Right.
And Roberts sided with the four liberal justices on the court, Ginsburg, Kagan, Sotomayor, and Breyer. And there was a dissent filed by, I think it was Justice Kavanaugh. Actually Kavanaugh. Yeah, that was joined in by Gorsuch and Thomas and Alito, and they would have held the governor's order unconstitutional.
Interestingly, you can correct me if I'm wrong, but it doesn't show that Alito joined in the dissent.
Oh, it doesn't?
No,
okay.
Just Kavanaugh, Thomas, and Gorsuch.
Okay, well, okay, well, that's good. Thanks.
Just thought that was. I saw that and just thought that.
Yeah,
was
that is interesting. So anyway, he did not join that I know of in the majority opinion, but of course the initial reaction of most people, as I read the comments under it, was Roberts is a grave mistake. Roberts is whatever. Here's another Bush appointee. Republicans never get it right. So on and so forth. Of course, so far we've gotten it right with Kavanaugh, we'd say, and Gorsuch, and of course Alito and Clarence Thomas. So we tend to make broad generalizations and sweeping statements. But I went to read the opinion, both the dissent and the majority, and there's all I think we really want to say to people today is that there's more here to be thought through than I'm mad because churches were not allowed to gather. And that seems to be a government prohibition on religious liberty. But the court is supposed to apply, quote, the law. That's all they can do. They don't make policy. They don't draw lines, okay? So I want to read a statement and say, listeners, take this issue out of the context in which it's written and listen just to this statement and see if you would agree with it. That our Constitution entrusts the safety and health of the people to politically accountable officials of the states to guard and protect. And unelected federal judiciary, which lacks background competence and expertise to assess public health and is not accountable to the people, shouldn't interfere. Now, if that was dealing with marriage, if it was dealing with abortion, and we're trying to protect the maternal health of a child or of a mother or the life of a child, we'd say, absolutely,
Yeah,
you're
we would
exactly
all agree
right.
with that statement unanimously,
Yeah.
for sure.
Yeah. Domestic issues were left to the states. Only national issues were given to the federal government. Whether we regulate or don't regulate medical professions in certain ways or recognize certain kind of familial relationships, those are domestic matters at the state level. They're not national matters. And I don't want my unelected black robe legislators, how many times have we heard that expression,
Yeah.
sticking their nose into my state business. What happened to federalism? What happened to separation of powers? By golly, I agree with that. Well, that's Robert's majority opinion.
Yeah. Except when they don't let us go to church. That's where
Except
we
when they
find
don't,
ourselves
yeah.
today. Yeah.
Yeah. And so you might say, well, what about the First Amendment?
Yeah, let's talk about why is this not a First Amendment issue?
Right. And there's a little bit
because that's
of
the
history.
general consensus, I think. Everybody's up in arms
Yeah.
because constitutionally the belief is, well, because religion is in the First Amendment, churches have an exemption seemingly for everything. So you cannot restrict churches in any sort of way, which I would sort of push back on that to say that, well, if that's the case, you would have to apply that to every area of law. Like, are churches exempt from following local building codes? Or are churches exempt? What else are churches exempt from? Anyway, but that's the argument
really,
that you're going to get into here.
Of course, the First Amendment doesn't say anything about churches. That's one of the problems with the Establishment Clause.
Right.
It just says the free exercise of religion.
Yeah.
And so my religion believes that I should have sex with underage girls. Do I have the freedom to do that or not? And so if we're not careful, what happens is we inject the government, particularly the court that's unelected, into questions of what's a legitimate religious practice, what's not a legitimate practice, okay? Well, that's exactly what was happening in England when we wrote the Freedom of Religion Clause, remember, in the Establishment Clause, was we don't want the 5 Mile Rule Act, part of the Clarendon Codes, I think it was called in England, that said, if you're not a certain kind of preacher, you can't live within 5 miles of the parish because you're the wrong kind of religious leader. Now, they were all purporting to be Christians, but the Puritan/Presbyterian Congregationalists did not believe in an Episcopal, Anglican, hierarchical church situation. It wasn't over, are we born sinners? How are we saved?
Right.
Yeah. So we wanted to try to get the government out of that, which was the purpose of the Free Exercise Clause. But if we're not careful, the next thing you know, we have the government sitting down and deciding, well, yeah, you're right. You do have a right because, who's to say your God's wrong? You can have sex with underage children. You can, take meth and, so on and so forth. And I might think that's a crazy religion.
Yeah. So
but
the
they
point
probably
is,
think mine's religion.
So the point is, we do have a First Amendment right for the free exercise of religion, but we are also bound by the law.
That's right. Right. And so what the Supreme Court said in 1990, and it was followed up in 1993, but originally it was written by Justice Scalia, who's often a hero of conservatives on the bench, is he said, look, if government had to take account of every kind of religious claim that anybody could make, we'd have no law. And he said, so the point of the First Amendment free exercise really is that we shouldn't discriminate against religions.
Yeah.
And as long as a law is, and I think the words were, as long as it's neutral on its face, okay, and it's of general applicability, then that's the law. And actually that was the law going all the way back to a case dealing with Mormons in Utah when it was a territory. And the guy said, according to my Mormon beliefs, I have to have multiple wives. And the Supreme Court said, well, no, we don't have to allow that. You can believe that if you want to, but the law doesn't pick on Mormonism. Nations across the world have for long periods of time thought there should be just one man and one woman. So So you're going against the whole force of history over here, and this is not picking on Mormons. It's just that's what marriage is for most people.
Yeah, it's not
So
the law's not being discriminatory. It's being applied
Yeah.
the same across everything.
That's right. Yeah, I might be a Christian. I might be Solomon and say, well, wait a minute, I want to have hundreds of wives and concubines. And the law would say it's a neutral application. Applies to everybody. Sorry, Solomon. Now, what you can't do is you can't pick on a particular religion. You can't target a particular religion or target perhaps certain practices and associate them with religion. So, for example, I can prohibit the smoking of marijuana. But if a church comes in and says, well, in our church, we get high to Jesus. Well, marijuana doesn't happen to be, I know you think it of like incense or something, but it's not. Marijuana is just a drug. Sorry. Now, so the Supreme Court said in that case in 1992 that you just have to look, is it content neutral? Does it apply to everybody? And then the court said, but if, this is in 1993, it specifically targets religion or appears to target religion, or it doesn't apply broadly, now the government has to have a compelling reason for why are we prohibiting incense, for instance, in public meetings. Is that really a latent way to get at the Greek Orthodox or somebody that would use incenses in the service? So we have to understand the First Amendment doesn't just say we all have liberty to do whatever we want. Now, the second thing is there is a federal law that was an attempt to undermine or reverse that decision by the Supreme Court that says, well, if a federal law imposes a substantial burden on a religious practice, then it has to have a compelling reason to do it, and the law that interferes must be narrowly tailored to achieve that objective of the government. Okay, so for instance, we don't want people to burn up, so we require all public buildings, with more than 50 people in them, to have water sprinkler system or a fire escape if it's more than 2 stories. And the court would probably say, well, there's a compelling reason there. We don't want people burning up in fires, not being able to get out of the second floor. And it applies to everybody, so it's not discriminatory. And there's really kind of not any other way to protect people from burning, if the building catches on fire. So that law would be okay. Okay. So those are just sort of the examples. Well, the problem is the federal law doesn't apply to the situation in California because it wasn't a federal order. It was one from the governor. Okay, so now it's either the constitutional question, which we've already talked about. Is the law neutral on its face? Does it specifically target religions or discriminate against religious people different from the way it deals with other people? It's not a federal issue. So is there a state Religious Freedom Protection Act? Well, you can imagine in California, there isn't one. Now, actually, that was the very second bill that our organization got passed in Tennessee back in, I think it was 2008, 7, 8, somewhere around there, that said that state government and local governments can't create policies that substantially burden a religious practice or belief without a compelling reason and the law being narrowly tailored. So in Tennessee, it would be a whole different question. But in California, they didn't pass a law like that. So the only thing those churches had to rely on was the First Amendment. Well, we just talked about that, right? Now, there's a quote from what Robert says that, and you may have that there in front of you, but he compares the restriction on churches to comparable secular gatherings, including lectures, concerts, movie theaters, spectator sports, theatrical performances.
And by the way, what you're mentioning, this is really the key that I've found. This is really the key difference between Robert's majority opinion and Kavanaugh's dissenting opinion is what they're comparing churches to. It's really the key difference.
Yes, that's right.
And so Roberts is saying, churches are similar to spectator sports and theatrical performances, large groups where people gather for extended period of time, and all of those places in California are being treated the same. They're all limited to 25%, maximum of 100 people in capacity, and it's something that when you and I were talking about this the other day in preparation, you sort of explained your take on that, and it made sense. If you said, when you think about if you're sitting in a church, someone's going to Walmart or a supermarket, they're standing 6 feet behind the person and they're constantly moving and walking around and probably not there for very long, versus a church, similar to a movie theater, similar to a concert venue. You're sitting next to someone, you're staying in that position for an extended period of time. You're probably there for an hour or more. Right. I think Roberts is probably right that those two things seem... It would seem more similar analogous to compare a church to a movie theater than it would a supermarket.
Yeah. I think it would. Now, the dissent, this is what makes for nice lawsuits, is the dissent notices that that the 25% gap that you were talking about doesn't apply to shopping malls and supermarkets and restaurants and pet grooming shops, but bookstores, florists, all those places, we're kind of in and out. We're moving around. We're not congregating. But it doesn't apply to factories. It doesn't apply to offices where technically you might sit for 8 hours, right? And it doesn't apply to hair salons, which I get my hair cut pretty short. But when my wife goes to the beauty salon, she's there for an hour or two, depending on what she has done. So perhaps the dissenters were picking upon those things. And here's sort of where Roberts kicks in, and the Christian community needs to think about the big global picture. Yes, I know this is something we really want to do, and we know there's a First Amendment provision. There isn't any right to grocery shop or go to hair salons that's in the First Amendment.
Which is the key point that people who disagree with what we're saying would make.
That's right. But the question is, and here's the key to me, is what we said at the top of the broadcast. Robert says this, quote, "Our Constitution principally entrusts, where do we want the power to reside?" Now ask yourself that question. Do we want the power of making policy, of drawing lines, of figuring out what's most analogous to what, being drawn by the United States Supreme Court or by people who represent us? What's the answer to that question? Pick a side.
For me, people who represent us.
That's what I would tend to say. I may not like where the line is drawn. I might have drawn it differently, but I can go petition, remonstrate. I can bring a bill next year. I can strip the governor's powers. I can do all kinds of things. What am I going to do with the Supreme Court? I don't get to vote for any of them. Can't impeach any of them. Can't remove any of them. I'd have to amend the Constitution, unless I can find a good way to challenge their opinion. So Roberts then goes on and he says, so we principally entrust those safety and health issues to politically accountable officials of the states. And I would agree. That's where I want most of my lines being drawn. That's self-government in a Republican. And then he goes on and he says, so when officials undertake to act in areas fraught with medical and scientific uncertainties, that's what we're dealing with sometimes with abortion, right?
Yeah.
Well, what do you want?
Right.
Do you want the court second-guessing me every time I say I think this protects maternal health? No, we're furious. Who are you to say that I can't protect maternal health by requiring this woman to have this bit of information? We get furious. So he says, so where those broad limits of not where you're not intentionally targeting, intentionally trying to discriminate, he says, they should not be subject to second guessing. Now this is quoting, by an unelected federal judiciary. which lacks the background, competence, and expertise to assess public health and is not accountable to the people.
It's my favorite statement of this ruling, period. Because if
Yeah.
they would apply that to
To
all
abortion
of their
and
rulings,
marriage? That's right.
it'd be golden.
That's right. Yeah, it'd be golden. It'd be like, okay, good. California doesn't want to protect
Wait
my
a minute,
church.
I don't
I'm
have
a
the
Christian.
competence to make this ruling. This belongs to the states. I'm going to let you guys
Yeah.
do your thing.
I'm
Thank
going
you.
to let y'all do it, and I'm going to let those that are accountable to you do it. And if you don't like it, move from California and come over here
Move
to
out of the
Tennessee.
state or change your leadership. This is your problem
Yeah.
to deal with, not the courts.
Yeah. Yeah. And so we get infuriated when liberals want to create a one-size-fits-all rule for the whole country. And so they run to the courthouse and say, no state is competent to make a judgment as to what protects maternal health. No state is competent anymore to decide whether marriage is a man and a woman, 2 men and 2 women, 2 men and 1 woman. States are just not competent to do that. You need to draw those lines. And we get furious. And Roberts was saying, I might disagree, like the dissent, as to where they drew the line. Maybe they included some factories and offices with greater freedom than perhaps they should have. Maybe they didn't get all the apples and all the oranges properly aligned. But why don't we let the voters of the state who care about these issues address it to those who represent them, rather than having me up here draw those lines. And I think we need to be cautious about what we do here. Now, does that mean Roberts is always right? No.
Yeah, of course
But
not.
when you look back at the Obamacare decision, where everybody got mad and he found it was a tax. Now, I think that was a real stretch. But I think, I could be wrong, based on a lot of what Roberts does, he is trying to get the court away from making all these line drawing decisions and letting elected, accountable officials make decisions.
Right.
Now, that doesn't mean you go out of your way to uphold them, but you are respectful of that division of authority, so you don't make up a tax when there's not a tax. But I think that's what he's trying to do. There's another little issue here that is not raised in this case, but a lot of times, and this is on the abortion case, this is on the governor's abortion legislation, where he has 10 different stages of fetal development at which we'll say, okay, well, we won't have an abortion here, but okay, if you don't like that court, maybe can we prohibit them here? Or if you don't like that point, how about here? One of the things Roberts, I think, is trying to get away from is what are called facial challenges to the constitutionality of the law. Now, that's sort of a term of art, but there are 2 kinds of lawsuits that are brought. One is the law is facially unconstitutional. It doesn't matter who you are. There are no circumstances, none, in which this law could be constitutional. There just aren't any. That's a facial challenge. Well, that's a pretty broad statement, And then there are what they call as-applied challenges. It says, well, this law looks pretty general, but wow, when you apply that to Gary Humble, who has 3 kids and a wife, and he lives in Franklin, and he works for a not-for-profit, wow, that law is a little harsh.
Hey, you're about to give people my social security number too, or what? What's going on?
Well, no, I put it on the
kidding.
website. Yeah, sorry. Actually, Gary has multiple wives and children by all of them. So,
Oh God.
So yeah, don't take me seriously. But you see, the difference is, and so what Roberts is trying to get away from in the court, I think, are these facial challenges, because that makes a very broad, sweeping statement, and the preference of the court has been in the past oftentimes, and I think they're trying to return to it, is tell me why this is unconstitutional as applied to you. Because I don't want to have to decide a question for the whole people of the state of California, if I can help it.
Yeah, that's good.
And so, that's another thing that we need, to appreciate. So,
the way I see it
hope this is
too,
helpful.
going back to a lot of the conversation we've had, I think on this particular issue, church, and I'll just speak to churches and Christians in general. I hate seeing us being in a position similar to the way progressives would operate, that we become a people who are simply an ends justifies the means. In other words, we believe this, and this, so however we can make that happen, well, it's good because, we're following the Bible. But what we tend in that type of scenario what we tend to miss is, well, what happens when the shoe's on the other foot, right? And
right.
So we were talking about federalism,
Right.
the idea that we have a sovereign federal government and we have sovereign states. I mean, the thing is, we've agreed for a long time, no matter what you believe, whether you believe in progressivism or whether you believe in Orthodox Christian doctrine, those are two sort of opposing viewpoints. Legally, in a society where we all have to live together, the best way to have the best things rise to the top is federalism and the consent of the governed and self-government. And I think as church people, we need to get okay with the fact that if you elect evil rulers, right?
Yeah.
You will get evil laws.
Yes.
So
That's right.
if you don't want evil laws in your state, laws antithetical to the gospel, then you better figure out how to start voting in godly men
The
and
right
women
people
in leadership. And if you can't do that, you might want to think about moving to another state who can and surround yourself with a group of people maybe who think more like you do, so that you can live life the way that you want. This is federalism.
Sure.
We don't want we don't want the courts deciding every area of our lives, because that's eventually going to turn bad, like it did with abortion and marriage.
Yeah, that's right. So, in fact, I was on an email string. There are 37 or 8 other groups like ours around the country. I may have mentioned this last week, but one of the national litigation organizations was trying to get Congress to pass a bill to protect all churches from lawsuits related to COVID. So that, if you showed up at church and you got COVID and it found out that the pastor or somebody in the church had COVID and that's where you got it, you couldn't sue the church because you didn't have enough hand sanitizer out or whatever else it was. And they wanted all of us to sign on to it. And I asked the question, one, Congress can only do what it's been delegated power to do. So where is the authority of Congress? On what clause of the Constitution does Congress have the right to tell people who can sue who in a state court?
I don't think they have that right at all.
Well, I don't know, unless it relates to interstate commerce.
Right.
Well, if you're going to say, well, the grape juice or the wine or the communion materials or the gloves the pastor used, they moved. They in Tennessee, they bought them from someplace in Illinois, and so that's interstate commerce. And now churches are a part of interstate commerce. Well, then everything's interstate commerce. Congress can do anything on everything. Well, that's how they justified Obamacare, right? So we need to be careful there. I said, so what power do they have? And the answer was, I said, why don't we just let states decide for themselves who they want to protect? See, businesses have this same problem. If I open up my barbershop and or my restaurant, and it turns out a server or a hairstylist had COVID, and I happen to get COVID, after going there, well, my first reaction is going to be sue that hospital or that beauty salon or barber shop and at least extract some settlement money from them, right? Well, let's each state decide to do that. And if California, again, wants to let you get sued into oblivion, move to Tennessee. Maybe we won't let you sue. But
just
the
leave
answer
California in California when you do.
Yeah. That's right. But the answer was, David, I agree with you in principle, but my state would never protect churches, so I'm for a federal solution.
That's a
okay.
problem.
So when you want to pass the Employment Non-Discrimination Act and apply it to everybody in the whole country, are you going to say, well, that's fair game? Everything is now a federal issue and everything is now a Supreme Court issue. As you said, let's just take one rule. I don't care. Know what it is. Know what the rule of the game is. And then let's play with it. So Justice Roberts, if you believe you're not competent in certain areas and the state was left to protect health, then would you butt out and get your colleagues to butt out on abortion and marriage? Thank you. That's all. Yep. That's good. Just butt out.
That would solve the whole thing.
Yeah. And the beautiful part, I don't think we've thought about it. We can't get into it. We're going to go too long. But, one of the great philosophical questions, and we won't trace its history, but just go back to Plato and Aristotle. The idea of unity and diversity. Is everything unrelated to everything? All we have is particulars. And Plato said, no, there's a unity that exists here. There are things that are true about trees. It's not that we just have 1,000 species of trees. There's a thing called treeness, that is true to the nature of what trees are. There is a unity here. And so that's been the great philosophical question. How do you have unity and how do you have diversity? No religion, no philosophy has ever provided a good foundation for that answer to that question other than Christianity, which posits a God who is one in essence, but three in persons, where they are not separate, but they're all co-equal in a unity, but a diversity. And so when I look at federalism, I think, what a beautiful picture of saying, we're a national thing. We should look at what things are important to make sure that as a whole, as a unity, we have to be in agreement on. And then what things can we allow diversity on? Think about the body of Christ. I mean, isn't that what it is? We're all joined to the head, so there's a unity. But, somebody over here wants to play,
someone wants to play lead guitar and someone wants to play handbells.
Yeah, that's right. Someone wants to play handbells. Somebody wants, or they want to sing out of a hymn book and hold it in their hands versus put Rock of Ages up on the screen. Right. We can have lots of diversity within that unity, and our founders tried to do that. And what's happened is we have destroyed our unity, we've destroyed our diversity by making everything have to be uniform across a whole nation. And then that creates anger. That creates division.
Because people have lost the ability to govern themselves, to live life the way they see fit.
Yeah, and move to those places that live more in conformity with where I am. And so that's the topic for today. And
it's good.
And I hope that as we see other things that courts may do, we'll stop and say, do I have all the facts? Am I just joining the herd mentality? Because when the Supreme Court does something, they're not always right, but it's probably more complicated than it looks to the naked eye. Otherwise, it wouldn't have gotten to the Supreme Court in the first place.
Right.
So,
all right.
Yeah.
All right. And listeners, no nasty emails about how we hate churches and all this stuff. We really need to think hard on our approach. And again, like I said, how we get this isn't about ends justify the means. There's an appropriate way to go about getting what we want, because we live under the rule of law, and that's why we live in the greatest country on the planet. Frankly. Well, thank you again, David, for your insight. And as always, everybody, you can email us at info@factn.org. That's info@factn.org. We'd love to hear your questions, comments, and we'll see you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.